Welcome very much to the Judicial Integrity Network in ASEAN webinar on emerging technologies and judicial integrity. And I am pleased to invite for the opening session Mr. Nicholas Booth, Governance Team Leader at UNDP Bangkok Regional Hub. Over to you, Nick.
Good morning, everybody. Thanks, Liviana. So as Liviana said, I'm Nick. I'm the head of the Governance and Peacebuilding team here at UNDP Bangkok Regional Hub. I'm really delighted to see so many of you here today, many old friends, some new faces too. It's been quite a while since we last met, so it's great that we meet today. Everybody on this call knows how important judicial integrity is to a strong, well-functioning justice system. And rule of law and justice are core values in ASEAN, and across the whole of the ASEAN region, we have judges bringing their strong leadership and commitment to strengthen their judicial systems and to make integrity a core value of the judiciaries in which they serve. And we've been proud and privileged in UNDP with the support from US Department of State's INL Bureau to work with you through the Judicial Integrity Network ASEAN, which was from the start designed as a network of judges from ASEAN countries for judges to share ideas and to really support the joint efforts to integrate the Bangalore principles on judicial conduct into the lifeblood of the courts in ASEAN. And it's exciting now that we're in the third year of growing the network, and we're happy that so many of our judicial partners and INL are still sharing our shared vision about the critical role of judicial integrity and continuing to forge the way ahead. And again, I should mention our strong partnership with the UNODC and the Global Judicial Integrity Network, which is doing a lot to promote resources and awareness about judicial integrity worldwide. And we really take our cue from that and help implement those approaches to make the Bangalore principles come to life in our region. And so it's great to have participants from Vietnam, Thailand, Malaysia, Philippines, Indonesia, and Laos today. And I'm really looking forward to hearing about the outcomes of today's research. And this started really when we last had our in-person meeting a few years ago, back in the days we could hardly remember before COVID. It seems a long time ago when we could meet in person. And they've been refined since. And I know that the question of digital technologies and whether they strengthen or how they can strengthen access to justice and whether they provide opportunities or risks for judicial integrity, it's a very live question, and the COVID epidemic has really done an awful lot to strengthen and accelerate digital technologies at a dizzying speed, which many of us could hardly have imagined, and so many of the judiciaries in our region and elsewhere. So what are the implications of that? What are the opportunities and what are the risks? So I'm really happy to discuss those questions today with all of you, and I'm also really happy that we have a number of our advisory group members today. I want to thank them for their leadership and expertise and the perspectives that they bring. I'm very honored to recognize Justice Shirini Tilakawardene, who's consultant to the Sri Lanka Judges Institute and a national international arbitrator and a former acting Chief Justice, Supreme Court judge in Sri Lanka. We have Laurie Glanfield, Deputy President of the Australasian Institute of Judicial Administration, Dr. Nihal Jayawikrama, who's a rapporteur of the Judicial Integrity Group, a former Attorney General and Secretary for Justice in Sri Lanka, and an Associate Professor of Law in the University of Hong Kong and many others, and an Executive Director of Transparency International. We have the Honourable Michael Kirby, former Justice of the High Court of Australia and acting Chief Justice and former President of the International Commission of Jurists and a member of the UN Judicial Integrity Group, as well as a co-chair of the Human Rights Institute of the International Bar Association. We have Honourable Murray Kellam, former Justice of the Court of Appeal in the Supreme Court of Victoria. And I'd like to finally announce our last advisory group member who's going to give our opening address this morning. Jennifer Marie is chair of the Executive Committee of the International Consortium for Court Excellence. and she's given many papers at international conferences on the state court's journey towards greater organizational excellence in the administrative justice. She's deputy presiding judge of the state courts in Singapore, and she performs both judicial and administrative functions at the state courts. And she's also an adjunct professor at the law faculty at NUS. And we really appreciate her expertise and leadership, as well as all the other members of the Judicial Integrity Network. So with that, I'd like to pass over to Judge Marie, please, for your opening remarks.
I'm really pleased to represent the Judicial Integrity Network ASEAN Advisory Group here today. Now, I bring my experience as a judge in Singapore and, more importantly, as the chair of the International Consortium for Court Excellence. And it's my pleasure to bring these perspectives to the work of JIN ASEAN and to this event today. Now, this research project has provided a peek into the ASEAN judicial perspectives on new technology and concerns, as highlighted by some respondents to the survey. I shall share my experience in the use of technology in the courts and how the IFCE can be an excellent tool to help courts make the smooth transition to adapting to the new normal. We all have seen dramatic changes in court operations in the last decade. In the last 18 months, the pace of this change has sped up. Around the world, courts have scrambled to find ways to deliver justice services online. Hearings have been held by phone and by video. Judges have found ways to work from home. Court staff have received files or sent documents to lawyers and members of the public electronically. Of course, some of these technologies were already in place, but are now more widely used. Others were adopted just during lockdowns. We have seen firsthand why we as judges need to interact and be ready to interact with technologies. Traditionally, judges have focused on what happens in the courtroom, relying on the evidence that they can see or hear. However, we now see that judges must pay attention not only to what they see and hear, but also how they receive that evidence. Is the video platform secure? Is there someone else in the room with the witness influencing what they say? Has an electronic document been tampered with? Does everyone have access to the court process? Without a basic understanding of how technologies are being used this day, some judges may be less amenable in embracing it. Some judges think that they do not need to worry about or understand the technology that is used in their courtroom, trusting the court staff or the lawyers to sort out the technology. Now, when judges give up control of key questions of reliability and transparency, will the public lose confidence in the justice system? Judges must have a basic understanding of technologies and the vocabulary and the capacity to identify when technology is affecting trial fairness and ensure equality of access within the technological platforms. As judicial officers, we must stay current on these technologies and the impact it will have on our decision-making. Without judicial participation, new technology may well obscure biases and make it harder for judges to promote equality and fair treatment. Here, I would like to share very briefly, some experience of the State Courts of Singapore. I note from the survey that judges in many jurisdictions are concerned over their lack of involvement in the development of emerging technology for the judiciary. In Singapore, judges actually work quite closely with IT professionals to ensure that IT systems meet the rigorous requirements of an effective judiciary. To cement the importance of the use of technology in the courts, the judiciary established the Office of Transformation and Innovation. This was in 2019. And this office oversees the planning, formulation, and implementation of technology, data, transformation policies, and innovative and initiatives for the whole of judiciary. The OTI is helmed by a former judicial officer and a prosecutor, and the oversight of this office is by a High Court judge. Now, some of the technological initiatives that the OTI has come up with include an authentication system for court orders, a queue management system for remote hearings, and a real-time speech-to-text transcription system. In addition, transformation efforts across the whole of the judiciary are coordinated by the Judiciary Transformation Working Committee, which is overseen by the Judiciary Transformation Steering Committee. In relation to some court-specific technological initiatives, such as the Integrated Case Management System and the Community Justice and Tribunal systems, both of these systems are used in the state courts of Singapore. Judges lead and have continued to lead in the development and the ongoing renewal of these technologies as what we term them as executive sponsors. These executive sponsors provide leadership and strategic direction. They are also an important interface between the IT professionals and the other judges. One important area of focus is to ensure that the adoption of new technology does not compromise judicial integrity in favor of efficiency and convenience. For instance, we ensure that access to electronic records are aligned with our existing laws on disclosure of documents. While it is important for judges to take a leading role in the design and the use of technology in the courtroom, it is equally important to adopt a consultative approach. In Singapore, this is done by engaging court users to ensure that their needs and concerns are met when systems are rolled out. This is also very much in line with what the IFCE prescribes. Now, it may well be easier for a small jurisdiction like Singapore, with a huge mobile penetration rate in 2019 of about 152%, which is a useful proxy for internet access, to ensure that the judges have some idea or some clues about technology. As one of the founding members in the International Consortium for Court Excellence, State Courts has played an active role in developing the IFCE. Applying the principles of the framework has also put us in a better position to deal with the pandemic challenges. I would like to take this opportunity to share some of its recommendations on the use of court technology, which are relevant to several concerns raised by the survey respondents. Judges do indeed have a key role to play in identifying the needs of court users, particularly vulnerable users. As new technologies promote transparency and efficiencies, judges are the ones who will ensure that individuals in their courts are not left behind. The latest edition of the framework has provided a set of recommendations on the use of court technology in its annex. It covers 5 important aspects that courts should consider when adopting new technology. Listed on this slide are 3 of the aspects that address concerns raised by the survey respondents, and they are namely accessibility and transparency, competency, and ethical dimension. In addition to this list, several criteria statements under the framework's 7 areas of court excellence can guide courts to engage judges and court personnel in planning to adopt new technology. You may download, of course, a free copy of the framework from the ICC website as shown, and if you wish to find out more about the framework. Now, as judges, we can support each other in our learning and adapting as we face new challenges. Many of you will agree with me that it is beneficial to join regional networks to learn from judges across borders. The concept of judges supporting each other is also the strategy we have been using in promoting IFC within ASEAN jurisdictions. After conducting a Train the Trainer workshop in April this year, for representatives of the ASEAN Judiciary, the workshop participants were subsequently invited to join the ASEAN IFCE Resource Network with the aim to facilitate mutual learning and to share IFCE resources amongst members. The network has just held its inaugural roundtable discussion this month, where members exchange ideas on implementation and offered support to one another. The IFCE is a useful reference for courts that are seeking to improve their performance with the use of technology. Interested courts may consider joining the ASEAN IFCE Resource Network to understand more about the framework, learn from judges across the region on best practices, and form collaboration. The JIN ASEAN Network was established to create a regional network of judges to share expertise with one another. It is an excellent platform for ASEAN jurisdictions to share expertise, and this research came out of suggestions from judges in the region. The tools you will hear about at the end of this session are designed to make it easy for judges to benefit from this work. Strengthening judicial integrity across the region strengthens public confidence, facilitates global business, protects the rule of law, and promotes equality. As judges, we can support each other in our learning and adapting as we face new challenges. I look forward to seeing both networks expand in the coming years and help more ASEAN judiciaries to achieve excellence. With that, I wish all of you a fruitful discussion for the rest of this morning. Thank you.
Thank you very much, Judge Marie, for your intervention. It has been a very good introduction to the topic, and especially this invitation to judges and judicial officers to stay up to date with the technology's developments and to get an active role in choosing and co-designing this. I am pleased now to introduce you to my colleague, Sarah McCovery, who is the Judicial Integrity Consultant retained to conduct this research for the JIN ASEAN on emerging technologies and the judiciary. Sarah is a Canadian-trained lawyer, and she runs Calibrate Solution, a consultancy focused on the rule of law, gender and equality initiatives, technology, and systemic changes in the legal sector. So Sarah will tell us a little bit more about her research and the findings.
Thank you very much, Laviana. I'm pleased to share this research with you today, and it will build on many of the topics that Judge Marie has just highlighted for us. The research that we are looking at today focuses on emerging technologies and those technologies' impacts on judicial integrity. You know, when contemplating justice sector technologies, the judiciary is the expert on rights protection in the courtroom and is a key voice in the planning, the implementation, the monitoring of emerging technologies. This survey of judicial perspectives, some of them, I think from some of you who participated in the survey, seeks to really understand how technologies are currently being used by the judiciary and to identify areas where additional resources or tools will help judges to participate in the technological evolution of the justice system. Judges, as you know, are stewards of individual rights of the litigants in their courts, and are also acting to protect the broader integrity of the justice system as a whole. Judicial integrity is critical to public confidence in the justice system and to the stability of democratic processes and institutions, economic markets, and global relations. Judges protect the rights of all of the litigants that come through their courts. They see how women, children, and vulnerable members of society can be excluded or harmed by some practices. Judges can rectify these inequalities in individual cases and can bring this perspective of systemic discussions of gender, racial, and other kinds of discrimination into the process. This judicial perspective is critical to both changes in the laws, but also the changes in the technologies that are used in our courts. So recognizing that critical importance, I'm going to now share my screen and start to walk you through some of the highlights of the research itself. So let's start first with the concept of judicial integrity. We use the concept here as it's set out in the Bangalore Principles based on the 6 values of independence, impartiality, integrity, equality, competence, and diligence. And as you heard from Judge Marie's comments, these concepts have been further developed by the UNODC's Global Judicial Integrity Network and the ICCE's international framework around court excellence. These interlapping concepts of transparency and access to justice and public confidence all relate to judicial integrity because it touches on these different aspects of judges' conduct, including transparency in decision-making, transparency in court administration, predictability of case timeframes, equal access regardless of status, money, or identity, equal treatment regardless of status, money, or identity, mechanisms to prevent bribery, mechanisms to prevent gendered threats, due process, judicial independence, and the separation of political and judicial roles and institutions. So with this foundation of the key concepts of judicial integrity, this research is premised on a surveying that reached out to 100 judges across the ASEAN region, asking the judges to share their experiences with a range of technologies. And we looked in particular at the pandemic acceleration of court modernization, at virtual hearings, at artificial intelligence and machine learning, at online forms and e-filing systems, at case management that's either automated or electronic, and at different types of automated translation and interpretation technologies. I'm going to take a look at each one of these in turn and just give you a couple of the key highlights. So when we look first at online forms and e-filing, what was very evident from the responses from the judges who completed the survey is that electronic submission of forms is high, as is submitting arguments electronically, about 64 and 65%. Some courts or some judges also have experienced receiving evidence submitted electronically by the parties, others by the experts, and some by police. And of course, some of these numbers are going to be different, reflecting whether the judges who responded sit in a criminal court or a family court, perhaps in a court that hears business or corporate matters. You might see different use of electronic filing. One of the key observations here is that when judges shared their concerns about the impact of this kind of technology on judicial integrity, a number of them expressed concern about the risk of fraud and cyber attack in e-filing systems, and concern about the security of litigants' personal data as a result when it's submitted through an online portal. This concern around that security of data is important when we think about whether or not people continue to have confidence in coming to the courts as the place to have their legal conflicts addressed. Turning to electronic case management or automated case management, most of the respondents, as you can see here, have either a full or partial electronic case management system in play in their courts. And when asked about how difficult it is to use, 87% described it as either very easy, easy, or neutral. So the case management systems that are in use are ones that judges are finding simple and easy to use, and that they're used fairly broadly. Most respondents felt that case management was quite secure and it provided most or all of the information they required. They described different kinds of differential access for court staff, for judges, sometimes for the lawyers involved in a case. Others, though, noted that the case management system is not updated quickly enough. And so while somebody might have submitted new information, it was not yet available to them in the case management system. The pressures of that became more evident during the pandemic, when there was no other way to get that same evidence or those same documents. Others also commented on concerns about the security and confidentiality protections, sometimes actually being a barrier to judicial access to the complete case file, because some of those case management systems are designed first for e-filing purposes and hadn't necessarily contemplated the way the judge needs to access the information, or cases where more than one judge would be involved in a case. Turning to virtual hearings, something that we saw a lot more of during the pandemic, we can see here that 69% of respondents dealt with virtual appearances for lawyers, 41% for public or the parties, and 42% had expert witnesses who appeared virtually. For the most part, people feel that this is increasing both the ability of people to access court processes closer to home, whether that's in their community at a community center, for example, or from their own home. And also that it's seeing the speed of trials is improving or increasing because of that. Judges who responded to the survey talked a little bit about the kinds of complaints they hear from parties or from lawyers. And most of those complaints relate to internet availability and the stability of people's internet connection or the availability of technology. Parties in rural areas do not have the personal or the community access to the internet sufficient to participate in online hearings. Many lawyers do not have internet in their offices, creating disparity between the parties in a virtual hearing. Many judges heard complaints about the audio or video quality during the hearing. We recognize that many courts made a very quick pivot to use virtual hearings in place of online or of in-person hearings. And so some of these issues with the technology platforms happened across the globe because courts were having to move so quickly to try new platforms. Nonetheless, these are some of the issues that continue to need to be addressed if people are going to continue to hold virtual hearings. Both parties and judges expressed some skepticism that an accused person would be treated the same way online as in person. And I think that's very important when we think back to the aspects of the Bangalore principles and how much public confidence in equality of treatment is critical to whether or not people continue to trust judges and courts for fair results and for due process. So there continues to be a transition in how people are experiencing the virtual hearing, whether those are perceptions or whether those are based on other people's experiences. That's part of the change that will have to happen as virtual hearings become integrated into court operations. Turning to artificial intelligence or machine learning, when we can see here, 7% reported using predictive technologies in sentencing. 17% had used automated research tools that rely on an algorithm of some sort, and 14% used pre-populated judgment templates that had a machine learning component. And in these cases, you know, the artificial intelligence or machine learning is using a formula or an algorithm to apply patterns evident from the data that has been fed into the algorithm. So that might be past cases, past decisions, information about that particular defendant or offender in some cases in sentencing, and then using those patterns to predict an appropriate sentence. Also being used at times to predict whether or not a case should happen at a certain speed, whether or not certain kinds of steps should have happened in the progress of the case. When asked about these advantages, judges were quite enthusiastic about how artificial intelligence increases the speed of trial processes and consistency in decisions, and saw those both as primary benefits for the public and for the justice system itself. And now, very interesting here in the context of judicial integrity, respondents also said that AI is a tool for protecting judges from allegations of bias, for avoiding human errors, and for achieving greater efficiency that then increases the capacity of the court to address case backlogs. Now, so when we think about it that way, artificial intelligence is seen by judges as improving some of the transparency, fairness, and public access to the decision-making process. However, despite some of that enthusiasm, there are others who are concerned that artificial intelligence removes the human elements of judging and produces decisions that aren't based on those humane principles that individuals bring to the judging process. And so there, I think we see some of the tension between the speed of introducing these tools and the need for them to be simply tools that are then actively used by judges who retain their discretion to make decisions that reflect the individuals and the facts before them in the court. You'll see that final stat here on the slide. When asked about whether or not judges understood or had access to the data that was being used to train a machine learning system, 68% said they did not receive any or enough information about what those data sources were. Only 4 people who responded felt that they had confidence in the source of the data that was going into the artificial intelligence. Now, that doesn't mean that all of the rest of the people thought there was something wrong with the data. They just didn't necessarily have any information about it. And I think you'll see as we get on to some of the recommendations in the research, ensuring that judges are part of the process of understanding and assessing the quality of artificial intelligence data is an important part of maintaining the judicial oversight of the way that technology is being used in the courts. So I'll turn quickly here to court transparency. You can see here from these charts that most respondents felt that the technologies were increasing access for the media and increasing the way people could view or participate in the hearing process in ways that increased court transparency. Access to justice is another key angle to look at issues of judicial integrity, because as we know, a system that is not accessible to everybody is not a fair system, and making sure that we don't get enthusiastic about the technology because it works for a majority and we leave people out of accessible, fair decision-making is a failure of the system as a whole. So here, some of the key observations are that judges reported some fairly mixed results. That technologies are generally increasing access to justice, but they have a mixed impact on vulnerable groups, including people with lower education or economic levels, as you can see in these charts. The examples, though, really are mixed. Technologies hold great promise for people with disabilities, offering ways for people to communicate directly with the judge without having to rely on someone to perhaps read documents out loud or speak on their behalf. For the elderly, though, new technologies are often unfamiliar and intimidating. Another example of a mixed environment, women who are facing violence may benefit from being able to testify from a remote location. They may feel that keeps them safe. In another context, however, the fact that they're testifying online makes it more difficult for the court to protect against coercions or threats to that same woman who is testifying. So again, we see the mixed implications of technology around access to justice. Technology doesn't solve all these issues. And as one judge said, in face-to-face trials, they have no money to go to court. In virtual trials, they have no access to cell phones and they don't have the technical know-how. So technology isn't by itself a perfect solution to the issues of access to justice. Throughout all of these areas of technology, judges shared a number of concerns that really cut across many of the technologies. And I'm going to just touch on each one of them here. There was a significant concern about the impact of technologies from a gender equality perspective, that sometimes when we introduce technologies, it can be used to erase someone's gender or other aspects of their identity so that we are no longer able to notice and to track the differential treatment on women, on LGBT individuals, on people with disabilities. And so having a clear attention to gender and to equality is still a critical role of judges. When we look at bias, there's increasing research and data into the issue of the way artificial intelligence algorithms can import the same biases that might have been evident in the decisions that are fed into the algorithm. But now those biases are harder to identify and harder to call out because they have been, again, sort of erased or made invisible by the technology. Many of the respondents are concerned about privacy, both the privacy of litigants' data, as well as the privacy of people participating in the court process, whether those are child witnesses themselves as judges or judicial officers who might be having to appear from home, the lawyers who are now appearing from their office. Some of the ways in which the court protects against people seeing that information is disappearing with these technologies. Data protection is a significant concern. People talked about the issue of who owns the data and what happens when private sector technology providers are providing solutions like Zoom that we're using here today, like different kinds of products, whether it's from a major distributor of those products like Microsoft or Zoom, or whether it's one that's been developed by a private sector partnership. Who owns the data that's being stored in that? And are there sufficient protections to make sure that that data isn't being used for any other purposes, isn't being integrated into or sold in different ways, even if it is being anonymized in some way? There's a general concern over who decides what is appropriate for technologies in courts. Should this be decided by the court, led by the judiciary, or should it be decided by the government? And typically, these two parties are both important in the decision, but it's easy when you imagine that the government's concern is focused a lot on efficiency, speeding up the process, dealing with backlogs, and addressing or minimizing the funding, that those criteria and those priorities might be different from the judiciary's concern about the rule of law, about access to justice, about maintaining protections in place that ensure or give confidence in the integrity of the individual judge, of the process itself, and of the decision. So again, we see there that idea of private ownership as a long-term issue. Who's responsible for updating the technology? Who provides the training? And then finally, judicial discretion. With all of these technologies that offer ways to make it easier for judges to deliver the services that they are focused on in court, including generating decisions, these can be useful tools so long as judicial discretion is still built into the application of those technologies. And so again, this comes back to that idea of retaining that human aspect of judging and recognizing that judges hear and respond to the people in front of them in court in a way that is critical to protecting public confidence in the administration of justice. Now, out of this research, a number of recommendations emerge about how judges can use their position of leadership, whether in the courtroom or within the planning and administration of the courts themselves, to protect judicial integrity, rule of law, and access to justice. So here we see, moving from the top across, judges may need more support to do each of these things, but with support, judges can ask questions about the data that's being used to train the algorithms. Judges can identify gender, racial, and identity-based bias in the machine learning training process before the algorithm has been created. judges can receive and review detailed briefings about how that process is being done. Turning to what's happening in the courtroom, judges can prepare litigants and witnesses for what that virtual process, decorum, technology use is going to look like, and really eliminate some of the fear or intimidation that litigants might feel when they're in the court process. Judges can raise rule of law and trial fairness criteria when new technology is proposed. And often we know when a new technology is designed, judges might be asked about how frequently they need access to something, what kind of platform they use, what kind of training they need. There's also an opportunity for judges to use and bring their expertise in those moments to also talk about what they know about equality, trial fairness, and rule of law. Again, strengthening public confidence in judges' role and confidence in the integrity of both the individual judge and the process itself. We know that judges need to scrutinize evidence that comes before the court. Increasingly, there needs to be support to judges to scrutinize the evidence that is presented through these new technologies, to make sure that they're aware of and looking for the right indicators that that is reliable evidence. To support judges to promote an understanding of the court processes with litigants and witnesses. What might have been obvious when you're in an in-person courtroom or you're watching the 2 or 3 matters before yours is called is not as obvious to the individual who is signing on to a virtual hearing and doesn't understand who the different faces are on the screen and why the process is happening the way it is. The way that a judge controls the courtroom proceeding might need to change in these new technologies in order to cultivate that public confidence in the integrity of the process. And then to, of course, support judicial colleagues to build the skills and understanding of these new technologies themselves amongst their colleagues, and to maintain rigorous attention to the avenues for corruption that happen within the courts. And those don't necessarily stop or start with technologies. Again, technology is a tool. It's one of the ways that we address issues of trial fairness and judicial integrity. So those are the highlights of the research. And now, having done this research for JIN ASEAN, the next step is to figure out how to use this to support judges in all of those 9 areas of recommendations, to use this so that all of you and your colleagues and the people that you're working with within the region are able to make really good decisions about what's happening in the courtroom and within the evolution of technology in the courts, whether that's in your specific court, whether it's in the country or the region as a whole. This brings us to our last component of the day here today, in that based on the research and then also some of the feedback that I'm about to ask you for, JIN ASEAN is preparing tools for judges to support you and your colleagues as you engage with emerging technologies. These will be tools informed by the research that address those recommendations. And, we know that judges are not always in charge of procurement or all the technology decisions, nor should they be. But often judges are asked about the key components of judging, or asked what you need in your courtrooms. Other times you might know how technology is negatively affecting one group of people, has a gender bias in it, how is affecting public confidence. And you have an opportunity to share that perspective in the design of a technological development in your court. As people tasked with protecting rights and delivering that fair, unbiased, transparent administration of justice, your perspective on new technologies is invaluable. So the tools that we're imagining are designed to support you to comfortably participate in that design process and to bring your judicial expertise into the process. We want to make sure they're useful. And so I'm going to show you 3 samples of what we're thinking about, but then mostly I'm going to ask you some questions. Do you want them or not? Are these the right kind of tools? How do we support judges, yourself as an individual, or you and your colleagues, to be having more conversations about the impact of emerging technologies, and how do we use these to address those recommendations and those needs that we see emerging. So here, I'm going to walk through these very quickly. The tools that we're proposing at this stage include a description or identification of which technologies are part of which court processes, a bit of a primer on different emerging court technologies to build the knowledge and vocabulary of judges to engage in the conversation, some criteria for judges to use to evaluate new technologies, the rule of law considerations in the courtroom of the use of technologies. Here we think about evaluating evidence, for example. What are the access to justice implications? We'll have a checklist to help you think about access to justice implications as that's happening in the design process. Some templates for bringing your perspective into project design or procurement processes. Some topics for judicial training or research. And a bit of thinking about what the judicial implications are of the cycle of technological change. So I'll let you take a look at 3 quick samples before asking you questions so that you have a bit more sense of what it is that we're imagining here. This is an example of a tool that identifies on the left-hand column different stages in the legal process, such as reporting a legal issue or being involved in the hearing or appealing a decision, and identifies different kinds of technologies that are already being developed or will be used in those at that process, together with the public users need and the judicial need. So just to look at one of them as an example, at the process of starting a legal case, the kinds of technologies might be e-filing, forms wizards that fill out forms for people, guided pathways. The public is concerned about whether they're easy to use. The judge is concerned about whether different people have access and can they access the forms. So some different kinds of concerns identified according to different processes. You can see where blockchain might be relevant compared to where an app to report domestic violence might be relevant. So this is an example of one tool. An example on the primer on emerging court technologies, and here I'm only going to show you the example on AI, would be sort of a short cheat sheet for you to be able to have some of the key definitions, some examples of the applications of this technology in courts, and then starting at the bottom of the page, and I'm going to flip to the back, the data and privacy implications of this technology, the proprietary implications, the access to justice implications, the rule of law implications, and the judicial integrity factors. This would be a way for you, knowing that something is coming, to fairly easily get up to speed on the vocabulary and what the consequences might be for court operations, to start to talk about that new technology. This primer would include this kind of short summary for each of the kinds of technologies that we've been talking about today. And the last sample I'm going to show you before asking you what you think we should be doing is one where this would give you some criteria that you could use if you're asked to participate in planning or design around new technologies. And here on the left, you can see some of the judicial concerns: protecting the rule of law, supporting a more transparent court, increasing tech capacity, and the kinds of criteria or questions that you might be asking in the course of that discussion to make sure that user privacy is protected, that data is secure, whether or not it's facilitating a cross-profession, solicitor-client privilege protections, these kinds of examples. So these are ideas of the kinds of tools that we are thinking about. Those are 3 examples of the first 3, similar kinds of ones around checklists that you could use in your courtroom, ideas for training and research, those kinds of things. I think really what we've been hoping to do today is share the research and plant the seed in your head in different ways about how you want to pick up these themes and how the Judicial Integrity Network can support you doing that.
Thank you very much, Sarah. I want really to thank you and all your team at Calibrate Solutions and the facilitators, Nikina, Christine, Meredith. It has been really exciting and useful to be part of this innovative workshop. So it has been really important for us also to get this feedback. I think another good news that I can share with you all is that the GEAN ASEAN is also continued to be supported also in the coming years from the US government. So we will continue with this project and we hope more and more to engage with you actively and to increase the participation of the ASEAN countries and the members. So please feel free to get in touch with us, subscribe to our newsletters, but also do not hesitate to reach out to either me, Sarah, or my team if you want to suggest something also to go forward. One other research thread that we are going to further develop, and we have already started to do some work, and some of you have already participated in a survey, is on gender and judicial integrity, on the gender threats to judicial integrity. And we are currently also exploring cooperation with the International Association of Women Judges in the coming phase. So we really hope to be back to you very soon, also with some additional resources and maybe occasions of discussion and sharing. I thank you very much, all of you that participated also so actively in this innovative workshop and interactive session. So till the next time then, thank you very much. Goodbye.